In the last class, we saw the Supreme Federal Court and the National Court of Justice. I mentioned the original jurisdiction of the Supreme Federal Court, the appellate jurisdiction, and I mentioned also the creation by the Constitutional Amendment number 45 of 2004, the creation of the National Council of Justice, the NCO. And I also mentioned the background discussion about the constitutionality or not of the National Council of Justice. Let's see now in this class the superior courts, the Superior Court of Justice, the Superior Labor Court, the Superior Electoral Court, and the Superior Military Court. All the superior courts are at the same level. I mean, there is no rank among them. The difference resides only on the matters in the issue they are constitutionally entitled to. Let's repeat. There is no rank among the four superior courts. Okay? There is no rank. The difference among them is the subject, the matter that they are entitled to. Let's begin with the Superior Court of Justice, that in a certain way is the most important one. Not because it is above the other, but because it has more things to do. It has a broad competence. The most important court in the last resort concerning federal law, the Superior Court of Justice. A Superior Court of Justice's decision only about federal law is not subject to appeal unless it also deals with a constitutional subject. Let me explain. A decision from the Superior Court of Justice just about federal law, it's not subject to appeal. It's the last resort of federal law. But if in the decision there is a constitutional subject, there is a possibility of an appeal for someone to fill a form to the case go to the Supreme Federal Court. In this case, only because of the constitutional issues, there is a narrow possibility for an appeal. In this case presented to the Supreme Federal Court, there is no possibility of an appeal from the Superior Court of Justice to the Superior Electoral Court. There is no possibility. The appeal just to the Supreme Federal Court. Otherwise, the decision of the Superior Court of Justice is unappealable. The decision is unappealable if the decision is just about federal law. But if we have a constitutional issue, there is a narrow possibility to the case be presented by the Supreme Federal Court. Be presented before the Supreme Federal Court. Original jurisdiction of the Superior Court of Justice. Original. Let's see here. Original jurisdiction. A broad, very different cases, but I will mention 2 or 3. Original jurisdiction to judge habeas corpus and the writ of injunctions against ministers of the executive body. Also, original jurisdiction to decide, in case of crime, some authority of the country, to judge some authority of the country, like state governors, judges from federal regional courts, state appellate courts, and members of the State Council of Accounts. That's the original competence in case of crime. Appellate competence. Appellate competence of the Superior Court of Justice. Okay. Appellate competence over appellate jurisdiction over all federal issues decided before the Federal Regional Court and state appellate courts. The Superior Court of Justice is composed by 33 members. You remember? Supreme Federal Court 11, National Council of Justice 15, Superior Court of Justice 33 members, justices, chosen among Brazilians, citizens, over 35 and under 65 years of age, of notable juridical learning and spotless reputation. It is private prerogative of the President of the Republic to appoint the justices to the Senate, which may be approved or not by an absolute majority. So, how someone become a Superior Court of Justice? She must be appointed by the President of the Republic before the Senate. Where do the 33 justices of justice, where do the 33 justices come from? Where do they come from? They are divided in 3 parts of 11 each. Let's see. Okay, here, let's see. We have 11, that is 1/3. We have 11, that is 1/3. We have 11, that is another 1/3. So we have 33. 11 members are chosen among the 5 federal regional courts. 5 federal regional courts. We have 11 members that exist in the country. Okay? So, from the federal regional court. Other 11 members from the State Court of Justice, that I call also appellate courts. There are 27 in the country, state appellate courts. Okay? The last 1/3, the last 11 is chosen, the 1/3 is chosen by the constitutional 5th criteria. Do you remember in a class that I talked about the constitutional 5th criteria? That's the criteria in the federal constitution that lawyers and prosecution are picked, are selected to be members of some courts, not all courts, because there is no 1/5 criteria here. There is no here in the Supreme Federal Court, but there is 1/5 criteria to the Superior Court of Justice. So, the last 1/3 chosen by the constitutional 5th criteria, mentioned in the Article 94 of the Federal Constitution. The constitutional 5th criteria, which I mentioned earlier, consisted of 1/5 of the seats of some court shall be occupied by members of the public prosecution and lawyers, both with over 10 years in office and professional activity, respectively. In the case of the Superior Court of Justice, it is not 1/5, but is 1/3. The shares that shall be divided equally between lawyers and members of the public prosecution. Yeah? The criteria to choose is 1/5, but the number is 1/3 of the lawyers and prosecution. A federal law may raise the number of the members of the Superior Court of Justice above 33. But since the Federal Constitution was promulgated in 1980, the minimum number of 33 remains the same. Let's see now the Superior Labor Court, okay? The other court of the superior court systems of Brazil. The Superior Labor Court is the most important court in the last resort concerning labor law. A decision of the Labor Superior Court only about labor law is not subject to appeal unless it also deals with constitutional subject. The Superior Labor Court has original and appellate jurisdiction. Original jurisdiction to decide relevant issues concerning labor law. Appellate jurisdiction over all labor cases decided before by the regional labor courts. Composed of 27 justices chosen among Brazilian citizens over 35 and under 65 years of age, of notable juridical learning and spotless reputation, appointed by the President of the Republic after approval by the absolute majority of the Federal Senate. Where do the 27, they are 27 members, where do the 27 justices of the Superior Labor Court come from? According to the Federal Constitution, Article 111A, 1/5 is chosen among lawyers effectively practicing their professional activity for more than 10 years and from among members of labor public prosecution with over 10 years of effective exercise, with due regard for the provision of the Article 94, which means the constitutional fifth criteria. The other 4/5 of the 27, they are chosen among career judges of the Regional Labor Court nominated by the Superior Labor Court. So, Superior Labor Court, the last resort in labor case, original and appellate jurisdiction. When they decide just about labor cases, there is no possibility of an appeal, but when they decide about constitutional subject, there is a gate, a narrow possibility of an appeal from the decision of the Superior Labor Court to the Supreme Federal Court. Superior Electoral Court. Superior Electoral Court. The Superior Electoral Court is in the same rank, but it is a little difference. They have some difference. That's not just the subject. There is difference, but there is not just the subject. The Superior Electoral Court, as the other Superior Court, has seat in the federal capital, and it is the most important judicial body concerning electoral subjects. It has the last word in electoral cases. The Federal Constitution states that the decision of the Superior Electoral Court are unappealable, except those which are contrary to the Constitution, and those deny habeas corpus or writ of mandamus. In these scenarios, someone can appeal the decision by taking the case to the Supreme Federal Court. 7 justices, just 7, 33, 27, 15, 11. Okay? 7 justices compose the Superior Electoral Court. The Supreme Federal Court has an important role. The Supreme Federal Court has an important role in the process of choosing the members of the Superior Electoral Court. According to the Federal Constitution, the Supreme Court shall elect elect among its members 3 justices and appoint then to the President of the Republic the name, I will say it again. The Supreme Federal Court has the competence to choose 3 members, to elect 3 of its members to be members of the Superior Military Court. And it also, the Supreme Federal Court, appoint the names of 6 lawyers of notable juridical learning and good reputation. Among them, the Chief of Executive will choose 2 to be members of the Superior Military Court. So we have 3 from here, the Supreme Federal Court, 2 lawyers that the Supreme Federal Court appoints 6 to the President of the Republic, and the President select 2, 3 plus 2, 5, and we have the last 2 names that will be chosen by the Superior Court of Justice among its members. The last 2 names. The last 2 names come from here. So we have 2 plus 2, 3 plus 2 plus 2 equals 7. 7 members. Okay? Well, the President and the Vice President of the Superior Electoral Court will be elected among the justices of the Supreme Federal Court. And the electoral corregidor justice from the members of the Superior Court of Justice. So the President and the Vice President, that's what the Americans call Chief Justice, will be chosen in the members of the Supreme Federal Court. Okay? All the judges in Brazil hold their office as long as they have good behavior until the age of 70 years old, when by law they have to retire. It's mandatory. All officers here in Brazil at the age of 75 they have to retire. Public officers. To be more precise, all public officers, as I said, but differently than the other courts, all the members of the Superior Electoral Court have a 2-year term according to the Federal Constitution. 2-year terms. That's the big difference of the Superior Electoral Court. Okay? Well, these numbers related to these things, okay? 3, 2, 2 equal 7. Not here, okay? I'm sorry. Superior Military Court is another thing. I'm talking about this court, okay? Well, so they have a term of 2 years, 2 years in office. Superior Military Court, we are finished. We are finished the Superior Court system, okay? Let's talk about the last one. 15 justices compose the Superior Military Court, all appointed by the President of the Republic after their nomination has been approved by the Federal Senate. The Electoral Superior Court, this one, or the Superior Electoral Court, and the Military Court, the Superior Military Court, have something in common because both of them are different than other courts. These two, the Superior Court, Electoral Court, and the Superior Military Court, they have big difference than the other court. I will say why. The Electoral Superior Court is the only court in Brazil where they just have a term, a specific period of time in which they exercise their judicial power. On the other hand, the Superior Military Court is the only court in Brazil composed of some members of which the Constitution does not demand a law degree. Among the 15 members of the among the 50 members 3 shall be chosen from among general officers of the Navy, Admiral. 4 from among general officers of the Army. 3 from among general officers of the Air Force. All of them in active service and the highest rank of their career, and 5 from among civilians. So we have 10 militaries and 5 civilians, equals 15. Okay? Well, regarding the civilians, they shall be chosen by the President of the Republic, over 35 years of age, from among Brazilians, 3 lawyers of notable juridical learning and spotless conduct, with over 10 years of effective professional activity, and 2 by equal choice from among auditors judges. Remember auditor judges that I said in a previous class, and members of the public prosecution of the military justice. So, we have, to conclude, we have the superior courts. They decide, when they decide about the specific subject that each of one deals with, there is no possibility of an appeal to the Supreme Federal Court. The possibility of appeal, it occurs only when there is a constitutional issue here, 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 or here. Okay? But when the Superior Labor Court decides a labor issue, a labor case, there is no possibility of an appeal to the Supreme Federal Court. With this consideration, we finish this part of our lesson about the Superior Court system. Thank you very much. See you in the next class.